Hi, everybody. Thank you so much for your patience, and thank you so much for coming to our first ever pre-law research symposium. My name is Zoe. I am the executive director of the pre-law review at Berkeley, and I will be one of your co-MCs today.
Hi, I'm Tabitha. I'm your other co-MC, and I am on the communications team for the pre-law review. And I am a junior here at Cal, studying linguistics and minoring in disability studies and developmental psychology. So excited to have you guys here. And yeah, let's hear from Zoe.
If everybody doesn't mind, I've prepared a few words. This is something that's been in the works for a while, and I'm just so excited for everybody to be here today. And again, thank you all so much for attending the pre-law review at Berkeley's first ever pre-law research symposium. After a very long year, we are finally here to discuss research, hear inspiring stories, and above all, support student scholars and future leaders in their field. Today, you will hear from students who have devoted their extra time and energy over the course of the semester to their undergraduate research, and from keynote speakers who are already well established in their field. It is my distinct honor to introduce and uplift the two student speakers we will be hearing from today. We will be hearing about refugee rights and geopolitical jurisprudence from our speaker, Nolan McMahon, as he provides an overview of refugee laws with the surrounding context of domestic and international political factors. We will also be hearing from Renee Paulraj, who will be giving a historical analysis on voting rights and suppression of voters past and present. Nolan and Renee's work will be published in our first volume of the Pre-Law Review, which is set to be released at the end of June, along with other articles from our incredible writers this semester. Additionally, we are honored to hear from keynote speakers Christopher Darden and David Oppenheimer. Both speakers today have worked in the legal profession for decades and are here today to impart their knowledge and wisdom to the next generation. I want to take a moment to reflect on how and why the review came to be and give space to this journey and all the labor that made this event and our first journal release possible. I came to campus fall of 2020 as a transfer student from Modesto Junior College. My path, as well as many other community college students, has not been easy. I was majoring in philosophy, but I always had the goal of going to law school. After numerous run-ins with the law, I did not feel safe around the police, and I knew that the law was used as a tool to oppress and harm people like me and other marginalized groups. However, my experience with legal services and their willingness to help me when no one else would made me believe that the law could be used for good as well. To know that UC Berkeley was filled to the brim with opportunities to challenge oneself personally, professionally, and academically filled me with joy. Having been a published author through the Bay Honors Research Consortium, I was excited to further challenge myself through the opportunities presented to me at UC Berkeley. I met Hannah, my former co-president, through another club. She approached me with the idea of starting an undergraduate law review on campus, something that she had always dreamed of being a part of at Berkeley, but wasn't available to her. She told me that she had presented her own research at the same consortium, and we hit it off immediately. Creating a space where we could perform the same kind of scholarship, this time in an entirely extracurricular capacity, and making this platform accessible to undergraduate students around the world became our mission, and the Pre-Law Review at Berkeley was created. For months, Hannah and I worked to plan out every detail we could think of, and finally, we were ready to bring on a staff to make our first publication a reality. We sat through 27 interviews in the span of a week, and though it was exhausting, we ended every night of interviews with, "These students are incredible." And it was true. We hired on a team of the most amazing individuals that not only had accomplished so much as undergraduates, but were willing to take a risk on a brand new organization with students that had just arrived on campus. For this, I will be forever grateful to our inaugural team of editors, writers, administrative team members, and especially my fellow executive board members. I want to thank my executive board that has been the backbone of this organization. Iana, Paige, Isabella, and Tabitha, thank you for being my rock and working tirelessly to propel this organization to the heights that I know it can achieve. The mission of bringing an elevated and accessible level of scholarship to the pre-law community at UC Berkeley is one that I hold dear to my heart. Whether law school is just around the corner or years away, our dream is that everybody who has a passion for the law and is willing to put in the work to create beautiful and thoughtful pieces of writing about it can do so through the pre-law review at Berkeley. Thank you all so much for coming today, and please give it up for our student speakers who are pre-law review writers and for the entire pre-law review team. Without them, today would not be possible, and this journal would not be possible. Thank you so much for your work this past year.
Thank you, Zoe, for all of those wonderful remarks. Now we'd like to especially thank our campus organization co-sponsors who have helped us promote and spread the word about this event today. And so we'd like to thank the ASUC offices of Senator Tellum, Senator Yaya, and Senator Castro for their work for the student body, and for coordinating the pre-law roundtables in which the review met and got to collaborate with other pre-law organizations. Your work allowed us to flourish as a new organization, and we are so grateful for all that you do for the pre-law community and the student community as a whole. Special thanks to Adriana Joe, who helped us every step of the way in our journey. So thank you so much. And now to Zoe.
We'd also like to lift up our co-hosts that are campus organizations like us, the Undergraduate Legal Honor Society, and Kappa Alpha Pi. Both of these wonderful organizations are working so hard to serve the student body through providing resources and other professional networking and social opportunities to the pre-law community. We are so grateful that you are here with us today, and we're so grateful for your partnership and your relationships over the course of last semester. And we are excited to be back in person with you all in the fall and to be able to continue on this partnership. So thank you so much.
And then thank you so much to our sponsor, Weil, Gottschalk, and Mings, and their support for this event. And support from organizations like Weil allows us to continue to flourish and publish these great events and provide an opportunity for students to challenge themselves academically for years to come. So thank you so much to our sponsors.
Thank you, Tabitha. And now I want to do something that is very special to me. I want to lift up and honor our graduating seniors, specifically our graduating senior editors who have worked tirelessly over the past semester to craft both Nolan's, Renee's, and Cecilia's pieces. We are so grateful for you. Our seniors have spent the most time on this campus, and they bring a knowledge and an expertise and an insight that the rest of the students don't have and are gaining. As a new organization, we cannot thank our seniors especially enough for putting the trust in us that they have and for imparting that knowledge and wisdom and insight onto us as an organization a, in its first stages. Um, David came to us and is currently working on Nolan's piece, and he has given um, so many good comments regarding the structure. And as a philosophy and a legal studies major, he has gained insights regarding legal arguments that he's imparted onto all of us that we are so grateful for. Megan is currently working on Cecilia Wolfkale's piece, and her knowledge, not only regarding legal writing and legal scholarship, having been a published author herself, but also institutional knowledge of UC Berkeley itself, has been invaluable in helping us navigate not only editing a piece, but also navigating being a registered student organization on campus. If you all don't know, not only is Megan the rock star editor, she is also the superstar senior class president, and is also will also be graduating UC Berkeley, but coming back to Berkeley School of Law. So although she will no longer be with the review, we hope that she will come back and visit us, especially since we'll still be on the same campus. So Megan, thank you so much for everything that you have done for the review and all of the work that you have put into it. Sam is also helping on Cecilia's piece, and his work has been absolutely invaluable. Sam works tirelessly to ensure that Cecilia is getting everything that she needs, and edits with a firm yet very understanding hand. And again, we are just so excited to have everybody here and our seniors. We love you and we will miss you so much. We hope that you will come back and visit us, but we'll never forget um, everything that you gave to the review. So thank you.
Okay, and so we are going to hear from our first keynote speaker, Christopher Darden. So he is a UC alum and a Bay Area native, so go Bay Area. He is a lawyer, actor, author, and lecturer, and he has received his law degree from the University of California, Hastings, and served as a prosecutor in the Los Angeles County District Attorney's Office for 15 years. He served as a prosecutor on the O.J. Simpson trial, and he has served as a commentator on many news networks such as CNN and NBC, and has co-authored multiple novels. So thank you so much, Mr. Darden, to be able to come speak to us today.
Thank you so much, Tabitha. Mr. Darden is here with us today, or is here with us right now. Whenever you are ready, you may start speaking. Thank you so much for being here. We seem to be experiencing some technical difficulties in this world of Zoom University. Stay on the line and we will be right with you. Okay, while we situate that out, there is no better time to have a captive audience than to give promotions. We actually want to make our first announcement, um, which is that over the course of this last week, the pre-law review has been fundraising for the East Bay Community Law Center. The East Bay Community Law Center serves low-income residents of the East Bay, especially Oakland and Berkeley, and also works with UC Berkeley law students to provide on the or uh, real or like in in-person training and clinics through the law school. They are a staple of the community and they help many low-income residents. I am excited to say that we raised almost $250 for the East Bay Community Law Center. Um, and so thank you everybody who has participated and who has donated. If you would still like to donate, you can email us and get our Venmo information. All proceeds will be given to the East Bay Community Law Center so that they can do the amazing work that they can continue doing the amazing work that they do. Um, Additionally, we are recruiting soon for our executive board positions. We are recruiting for an executive director and operations director. And so if you are interested in that, we will have more information. And yeah, so thank you again, everybody, for coming. And if you're interested in getting more involved with the review, please send us an email at calprelawreview at gmail.com. And give me 1 second. Oops. And I can see that our wonderful keynote speaker is here, and I have just made you a co-host, Mr. Darden. So please let me know if you're able to, yeah, if you need any sharing privileges or anything.
No, I do have a little PowerPoint that I'll be sharing if we can.
Yeah, of course.
Great.
You should be able to share and get started whenever.
Oh, okay. Well, first of all, good afternoon. Thank you for allowing me to be with you today. I was just at the beach in Malibu. I had to get back here. And so, I built in some time to arrive on time. LA traffic. Um, I prepared a speech. It is about this thick, but this thick, but I'm going to try and shorten it up. I am inspired by being here with you because I am just so happy about what I see in the world and what I see in the country today. And when I see all of you doing the things that you're doing, whether you're conservative or supposedly on the right or on the left, whichever it might be, I am thrilled to see the activism that I see today. Being at a certain age, that age which essentially runs the entire world, and you can see how well we run it. We're about to run it into the ground. I'm just happy at the notion that soon enough, and hopefully sooner than later, we'll hand over the reins to you, because I think you're the most intelligent and educated and insightful generation to come along in a long, long time. And I hope to be around long enough to see all the great things that you're about to accomplish. Now, I wasn't fortunate enough to attend UC Berkeley as a college student, although I did get admitted, by the way. And even though I got admitted in 1974, I couldn't go because I had a sister who was the first in my family to go to college, who attended Dartmouth. And she was part of that class, that first class at Dartmouth that included women. So she'd gone off to New Hampshire. And so my mother and father, neither of which had graduated from high school, were doing all that they could to support my sister. And so when it came to me, there wasn't a whole lot left. And so I didn't go to Berkeley because the tuition at Berkeley was about $400 a year. Mine was 1974. And so I went to San Jose State, where the tuition was more like $100 a year. But my heart has always been in Berkeley because I grew up in Richmond, which probably a little bit about, not too far away. I think you probably have an idea of how hard life can be there. So I didn't get to go to Berkeley. My two younger sisters did. I have a sister who went to Berkeley and obtained her MBA and another bachelor's in business. But the thing about life is that sometimes circumstances take you to a certain place, takes you in a certain direction, and in the end, it turns out to be the right place. And San Jose was the right place for me. I had wanted to go to Berkeley, not just because of the university, but because of my experience there. When I was in high school, I went out on a date with a white girl. And in 1974, that wasn't something that was especially popular. But there was this one place in the country, Berkeley, where different people weren't just tolerated, but celebrated. And even so, I remember walking around Berkeley and people saying things to us. We were 16 or 15 years old, actually, at the time. And people calling me the N-word and calling her an N-word lover, and awakening us, to a reality, about race and prejudice and racism. And it wasn't as if I hadn't seen some of that already, because I grew up at a time when political assassinations were the norm. Kennedy, King, Medgar Evers, Bobby Kennedy, and Malcolm X, and countless others. But I'd also grown up in a time where I learned about lawyers and how important lawyers were to bringing about change in the country. So, I grew up in a time when lawyers were an essential part of the civil rights movement and what they called then the advancement of colored people. And so I would see in the Jet magazine or in the local Black newspapers, or even in the Black Panther Party newspaper, or the Final Call, the Muslim newspapers, I would see these Black lawyers, these stories about these Black lawyers. And so at a young age, I learned about Thurgood Marshall. In the 1954 US Supreme Court decision in Brown versus Board of Education, which guaranteed all people, regardless of race or color, the same kind of education. And I grew up in Richmond at that time, learning about my own circumstances, my own reality, which was at the time I was growing up in segregation, even in California, even in the Bay Area. Because I lived in this 900 square foot house, me and my 8 brothers and sisters, all born within 13 years, with my parents who hadn't completed high school, and in a neighborhood where everyone was Black, except for the police and the store owners. And I grew up learning from my little perch, what America was all about. And so we would sit there sometimes in the 60s and we'd watch the black and white TV and eventually the color TV, and we would see what was going on in the world, the civil rights movement, young people like you who rode uh, buses, freedom buses down into the South to help bring about social change. And I watched these people and I watched them and I admired them. And I didn't just admire the academics and the speakers and the leaders, but I learned to admire the young people who got on those buses, who believed so much in justice and equality that they were willing to risk their lives. I'm hoping that you're made of the same ilk, and that when the time calls or comes, and when you're called to make a commitment, that you make a similar kind of commitment. And so I watched these events and I watched those assassinations and I watched people get beat over the head with nightclubs. And I watched what happened at Kent State, that massacre. And I watched what happened in Berkeley as police beat protesters at People's Park and in the neighboring community. And, they say that we're all a part, a creation of our environment and our experience. And all of these things help to create me, who I am today. But when I left Richmond for San Jose State with an idea. And the idea was that I would be a lawyer and that I would be a Thurgood Marshall. And that I would be like the lawyers that I saw represent the Black militants of the day. The fact of the matter is that the law, not just politicians, but the law had a dramatic change in civil rights, racial equality, and had a dramatic impact on my life as well. And so I wanted to be a part of that. I wanted to change the world. I wanted to argue in front of the United States Supreme Court. I wanted to stand up for the little guy and for the forgotten people and the people who the law and society um, had historically abused and misused. And so when I got to San Jose State, my education, my enlightenment began. I mean, because sure, I'd seen these things before, but you grow up in a segregated public school in Richmond and you learn about history, and the history you learn about in school isn't the history of America at all. And so in this period, my college days at San Jose State, I started to study African culture, taught to me by African professors. And I started to learn about the history of African Americans in this country. The most important thing I learned about African American history in this country is that there can be no American history without African American history, and that the two are more than just intertwined. They are one of the same, because African Americans in this country helped build this country. Not that African Americans were the only ones, but African Americans helped build this country and made major contributions to this country in politics, in science, in medicine, in entrepreneurship, in every important area possible. And learning about these things, again, helped to make me the person that I am today. And it strengthened my resolve to be a lawyer, and to be a lawyer who made a difference. When I think about the things I've done today and up to this point. And I think about my legacy as a lawyer and what people think about me, because some people love Christopher Darden and some people don't love Christopher Darden so much. Because as a young lawyer beginning in the LADA's office in 1981, I went there as a left-wing Democrat. And then I got there and I began to prosecute murder cases and child molestation cases and rape cases and burglary cases and robbery cases. And I began to witness, in a way, firsthand, man's inhumanity toward others. And it changed me for a while. I became far more conservative because of, again, my experience, because of what I was experiencing at the time. And I think for a while, for me, I put aside the thoughts I had, the inspiration I had gained from the marshals and from the militants and from my experience in Berkeley. And I began to become far more conservative. And I think my law school contributed to that too, because after leaving San Jose, I went to Hastings Law School across the bay, which at the time was far more conservative than Bolt Hall. When I went to Hastings Law School, they gave but number grades. And it was not uncommon for almost 50% of the minority law students at Hastings. It wasn't uncommon for 50% to drop out or fail the first year. And so for the first time, really, I was in a place where I was simply not appreciated. And in my view, not respected, not wanted. And there were expectations for me, I think, maybe not officially, but those expectations, I think, were that I should fail. I wasn't going to fail. Even before I went to law school, one of the things that I did was to seek out other Black lawyers, or not other Black lawyers. I was just trying to go to law school, but to seek out Black lawyers to find mentors, to find people who could support me as I studied law, and well, to help people move me along in my career as well. But when trying something new, it's always good, if possible, to have someone in your back pocket with more experience who can give you some of that needed advice. And so before going to law school, I went about looking for Black lawyers for advice, and I only found one from Richmond. And this Black lawyer from Richmond was very successful. He was in the law department at PG&E. And so I went to him. It took a while to get an appointment, and I went to him and I brought him my resume and my grades and everything, and I talked to him about my dreams of becoming a lawyer and the kind of lawyer I wanted to be. And he looked things over and he looked at me and he said, "You know what he said to me? I'm going to tell you what he said to me. He said, 'You shouldn't go to law school.' I said, 'Why not?' He said, 'You're not going to make it.' What do you mean? I don't think you have the ability to go to law school and graduate.' I was shocked. I couldn't believe it. This is the person I searched for and finally found. This was the person who was going to be my mentor, I hoped, and who would support me and help hold my hand through the law school experience. So what I found in him was what I had found in some ways, throughout my life. Someone who didn't believe in me, someone who wouldn't support me, and someone who doubted me. You may have had similar challenges in your life, and you may encounter similar challenges in your life. What I learned that day, because I hadn't learned it before, was you can't give a damn about what other people say about you or think about you. If you are motivated and committed to be an advocate, a legal champion for people who need advocates and advocacy, who need champions, who need someone who can speak for them because you can't speak for yourselves. You ignore all of that, and you ignore all of those people. And what I did was I went on to law school. And of course I passed in law school. Of course I graduated. Of course I passed the California bar exam the first time. Of course I had 15 employers trying to hire me. Of course. But I've been a lawyer now 41 years. And all of those 41 years was spent here in Los Angeles. I've been sort of a Forrest Gump, a fly on the wall, standing in the foyer or in the courtroom, watching every major criminal court or criminal trial verdict we've had in Los Angeles, from Rodney King to the Night Stalker, to O.J. Simpson, of course, and to any number of serial killers. And I've had the privilege of trying more than 200 jury trials. And I have handled more than 100 murder cases. And I've had the honor to travel all over the world, speak at universities all over the world, and to meet presidents and ambassadors, and no kings yet, no kings. I didn't meet Prince Philip, but I mean, I've had all of this given to me, even though some people didn't believe in me. I hope you believe in yourselves. I hope you believe in you, because the world needs you. No, and the country needs you. After O.J. Simpson in 1995, I left the DA's office and I went to a little law school in Los Angeles called Southwestern University School of Law, and I taught as an associate professor for 3 years, which was a great thing for me because it allowed me to get back in touch with who I am and to get back in touch with the basic principles and beliefs I held when I left my mama's house in Richmond and went to San Jose. And I began as an associate professor to study the law all over again. This time not to learn, but to teach. And I found my inspiration again. I was able to remember and retrieve again the reason I went to law school in the first place. And that was to speak for those who couldn't speak for themselves, to protect those who couldn't protect themselves, to stand up for certain principles that I had in 1974, but that I had forgotten about. And as I spent those years relearning the law and who I was as a lawyer, I I was happy to shake off the conservatism that had engulfed me after watching all the human suffering I watched as a prosecutor. When you're a prosecutor, it's hard to see the good in people. It's hard to think of people as being good because you see so much damage and carnage. But I was able to find again, the Chris Darden of 1974 and the Chris Darden of 1980, the 24-year-old that took the oath to protect the Constitution. The 24-year-old who became a member of the California bar. And so over the years, in my small way, in my little corner of the courtroom, in my little corner of the law, every day, no matter who I speak to or where I go or who I represent or whatever judge I stand in front of, I'm always reminded of my mission. And that is a mission to ensure that everyone is allowed to assert their constitutional rights and that they be allowed to access the protections the United States Constitution grants them. And that is a right to be free, free to marry, free to associate, free to congregate, free to choose, free to have the lawyer of their choice, that they be free to protest, that they be free of tyranny, and that this basic principle or rule of law that we should all subscribe to continues to be asserted, and that is that no one is above the law. So as I sit here, today thinking about, the law and what's going to happen next in my future, because yesterday I celebrated, my 44th anniversary as a member of Alpha Phi Alpha fraternity. So, I guess I'm in a reflective mood, but, I was at the federal detention center yesterday to see an inmate, and I saw this lawyer who's older than me, and I asked him, I said, how long have you been practicing? He said, 50 years. I said, 50 years. I said, aren't you tired? He said, yeah. I said, well, when are you going to retire? Because I'm not going to retire. Not yet. I said, well, okay, well, when? He said, when I get to a point where I feel like the job is done. When I get to a point where I feel like I've done all that I can. And I think that's a great way to look at it, because there are going to be a lot of lawyers, and there are a lot of lawyers that make millions and millions and millions of dollars, and you can evolve into that kind of lawyer too, if that's what you want. But I know for a fact that money doesn't feed the spirit. And for some of us who are true believers in the law, in the Constitution, in the rights of everyone, no matter who they are, we have undertaken this job. It's a job that we've sworn to do. And for many of us, it's a job we've sworn to continue to fight, to struggle, to do the right thing. That is either until we can't do it anymore or until the job is done. So pick your job, decide what kind of advocate you want to be, and you fight. And you be that advocate. You stand up for that little guy. You stand up for that woman. You stand up for that minority. You stand up for that transgender. You stand up for what is right. And know that all of us who came before you, somewhere rooting for you and cheering for you. You keep fighting until the job is done. Thank you. I'll leave my time up.
Thank you so much, Professor Darden, for coming to speak to us today. Your speech was truly inspiring, and we're so honored that you've made the time to come speak to us today. So thank you so much. Everybody give a round of applause. Another one, unmuted if you can. And thank you so much. Do you mind if we get a quick photo with you?
You want a photo? Should I put on my glasses, makeup? I did an interview for ABC News yesterday. And I
Perfect. And I'm just
didn't
going
have makeup.
to, I'm just going to take
that photo, this photo. Which photo do you want?
I'm going to take a quick screenshot, and everybody that has their camera on, just smile. Thank you so much again. And yeah, you are more than welcome to stay and hear from our next keynote speaker as well as our student speakers. But
and I appreciate that. You know, it is my birthday, and my family is celebrating.
Oh my goodness!
All of these years that I've spent on Earth, so I'm going to run. And no offense to the next speaker, but you guys just keep pushing, keep learning, keep trying to figure it out. Man, I'm just so excited for you and the life you're about to live. I know it's going to be amazing.
Happy birthday. We all hope that you have a wonderful birthday and a wonderful rest of your day. Thank you so much, Professor.
Thank you. Bye-bye.
Wow. Well, that was wonderful. Thank you all again for continuing to be here. We now have our next keynote speaker, who is Professor David Oppenheimer. David Oppenheimer is a clinical professor of law at the University of California at Berkeley School of Law. He serves as the faculty co-director of the Pro Bono program and the director of the Berkeley Center on Comparative Equality and Anti-Discrimination Law. Following his graduation from Harvard Law School, Professor Oppenheimer clerked for California Chief Justice Rose Bird. He then worked as a staff attorney for the California Department of Fair Employment and Housing, prosecuting discrimination cases, and was the founding director of the Berkeley Law Employment Discrimination Clinic. We are so excited to have you here, Professor Oppenheimer, and whenever you are ready, take it away.
Well, thank you very much. Thank you for inviting me. I want to do something maybe a little different before I start talking. I'd like to hear a little bit from you about your organization and what you'd like to hear about today, because I could take this in a number of different directions.
Well, this is an event. This is our first ever annual Pre-Law Research Symposium. We are the Pre-Law Review at Berkeley. We're a new organization on campus that seeks to provide students with pre-law scholarship, and we seek to make scholarship within extracurricular environments at the undergraduate level more accessible to students at Berkeley and beyond. Our writers are at Berkeley, but as well as from any other accredited college or university. Our keynote speaker before discussed his his experience as someone who went to undergrad and law school, and how legal scholarship and speaking to those of the past generation impacted him. If that's something that you are willing to do, we'd love to hear your perspective and your experience in your educational experience as well.
Sure. Well, that's great. Very good. So you're all engaged already in doing legal scholarship, in studying and writing. Let me talk a little bit about how I see legal scholarship as being integrated into the work of a law professor, and for that matter, of a law student, so that we can take the work that we do, all of us as legal scholars, and connect it more broadly to all of the work we do and how we lead our lives. So my responsibility as a professor is divided into 3 categories. And they're sometimes somewhat artificial, but those categories are teaching, scholarship, and service. And that's generally true at any leading research university. And if you're engaged in scholarship because you hope someday that you will be employed as scholars, that it will be the work that you do, you're likely to find yourself in a research university where you're responsible for teaching and for research and scholarship and for service. What that means for me at Berkeley is that I teach one of our first year foundational classes, which is the class in civil procedure. Civil procedure doesn't always have the reputation it deserves. Civil procedure is actually the funnest class in the first year of law school, if I can use the word funnest. It's the course that wraps together all of the other courses, because it's the course that explores the litigation system and the way we use courts to resolve disputes. It's a great class to teach. I think it's a great class to take. I hope it's a great class to take, because you're stuck. You're going to have to take it. It's required. I also teach a foundational second and third year course called the Law of Evidence. And it's a course on how we prove things in American courts. I teach an advanced course on civil procedure for foreign lawyers. And that in many ways is a comparative law course, because I compare the US civil procedure system with the systems from the various countries that my students come from, relying on them to teach each other and frankly to teach me. And I teach a course on comparative equality and anti-discrimination law. And what do I mean by comparative equality? We examine how different legal systems around the globe address problems of inequality, and we examine the anti-discrimination laws that have been adopted in various regions of the world and in various legal systems around the world. So we look at the US, we look at Europe through the European Union and through the Council of Europe. We look at individual states within Europe, particularly France and the United Kingdom. We look at Brazil. We look at India. We look at South Africa. We look at Australia, and then to a lesser extent, Canada and Mexico and Colombia and Argentina and various other states around the world. But the purpose of the course is to get a better understanding of how different legal systems, different cultures experience and address problems of inequality. That's my teaching. My service, I serve on a number of committees, both at the law school and at the university faculty senate level. If you end up as a researcher making a proposal that you will conduct some kind of research that involves human subjects, it will come through the committee that I sit on at the Senate level, where we have to approve all human subject research. At the law school, I have moved from one committee to another over the years. And then the big thing I do in the way of service is that I help oversee our pro bono program, where virtually all of the law students at Berkeley in their first year will do some actual practice on a pro bono basis. And we like to say of Berkeley law that we don't have a pro bono requirement. Many schools do, but we have a pro bono culture. And the result of that pro bono culture is that well over 90% of our students are engaged in pro bono work. And then I run a center on comparative equality and anti-discrimination law. And within the center, we have about 750 activists and advocates, academics from around the world who work on problems involving equality law and look for opportunities to collaborate rather with other equality scholars. And we have quite a few students, law students and undergraduate students, Berkeley students and students from other universities who work as research assistants and interns at the center. And many of them are involved in research projects. So right now we have a project where we are partnering with the Open Society Institute, which is a large foundation funded by George Soros that is committed to making countries around the world more democratic. And the project is on Islamophobia in Europe, with a principal concern with how face covering laws and head covering laws are being used to discriminate against Muslim girls and women across the European Union. We have 4 law students and 8 undergraduate students working on that research project. And we are working our way through the various European states. So we've produced reports on France, Germany, Austria. We're almost done with Italy. Next up is Poland. And we will ultimately, I hope by the end of this summer, primarily through the work of student researchers, be able to complete this report with Open Society on Islamophobia in Europe. This is one of a number of research projects that we're doing at the center in which we involve students in our work. That work in turn very much affects my teaching, particularly in my comparative equality course. So the book that I use for comparative equality, I actually have 2 books that I use, and both of them are books that I co-authored. Much of the work in those books comes out of the work of student researchers. One of the books is a book on the global Me Too movement, and A lot of the editing of that was done by students. The chapters were written by 28 activists from around the world, 44 activists from 28 countries, talking about what the Me Too movement looks like in various countries around the world, and talking about the intersectionality issues that the Me Too movement has in some instances addressed and in some instances not addressed when they should have. So that in turn becomes one of the books that I use in the course that I teach, which, by the way, this year I'll be teaching for the first time in the legal studies program, so it'll be available to undergraduates. And those students will write a series of short research papers as part of their participation in the course. And we're teaching the course simultaneously at 15 universities around the world. So some of the class meetings will be just me and my Berkeley students, but some I'll be meeting with my colleagues at universities all across the globe and all of our students together in one big Zoom room. That means that the research that my colleagues are doing in various aspects of comparative equality will become the source of lectures and discussion problems for the students in the class, who in turn will do research projects of their own. In my own research, separate from that with the center, I still very much am involved with students because I use student research assistants in all of those projects. And in some instances, the students end up doing so much of the work that they become my co-authors. So some of the papers that I write are co-authored papers with my students, and some are papers that I write on my own, but where I still have student assistance in doing the research and doing the fact checking and doing the site checking and doing the editing. I'll say a few words about the biggest project that I'm working on right now, with the hope that it'll be of some interest to you. For your generation, the idea that diversity has social value, and the idea that racial and ethnic and gender diversity are part of what produces a social good, are part of what makes our community, our society, our university a better place to learn, to study, to live. I think that's one of the foundational beliefs of your generation. Now, you're welcome to disagree with me on anything I say. That's a relatively new understanding of society. I can tell you that in the 1950s and 1960s and 1970s, the term diversity was rarely used outside of the field of biology. And the idea that racial diversity and ethnic diversity and gender diversity were things that made a society stronger or made a company stronger or made a university stronger, that just wasn't being discussed. It's not that people disagreed about it, it's that people weren't talking about it. And of course, the idea that diversity is a justification for affirmative action in colleges and universities is one which is very controversial. And so I was interested in trying to get a better understanding of how this term diversity and how this idea of racial and ethnic and gender diversity made its way into our discourse. Now, within law, which is the field that I study, the answer to that question is easy, because the first decision of a court embracing the idea of the benefits of diversity as a justification for affirmative action was the Berkeley case in 1978. The Berkeley case was an interesting case in that the decision of the court was the result of 4 justices saying that the University of California at Davis had an affirmative action program which was a violation of the equality provision of the US Constitution, the 14th Amendment, and 4 justices saying that it was not, and 1 justice saying that it was in this instance, but that affirmative action based on race was nonetheless fine if it was based on a university's commitment to diversity. And that idea seemed to come out of left field, or maybe center field. It was a very centrist idea. And yet, none of the other 8 justices were really enthusiastic about it. The 4 more conservative justices said, this is ridiculous. The 4 more liberal justices said, well, this is okay, but it's only one way or one justification for affirmative action. And yet it's become the blueprint for all American college and university affirmative action programs. And this idea of diversity and the benefits of diversity has spread throughout the corporate world, so that all through American society today, we talk about the benefits of racial and ethnic and gender diversity. I wanted to better understand where the argument in favor of diversity came from that had been adopted and embraced in the Berkeley decision. So working with a group of undergraduate Berkeley students and Berkeley law students, we began doing all kinds of database searches, looking for discussions of diversity that were linked in any way to race or ethnicity. And first of all, what we found is there were very few. We did find a law review article by a man whose name may be familiar to some of you, Professor and Judge Richard Posner. Can I see, just a show of hands, virtual hands, how many of you have heard of Richard Posner? Well, I'm not seeing any hands go up. Richard Posner was, thank you, Ty, the most productive legal scholar of the last 40 years. He is both, well, he recently retired from the Seventh Circuit, but for a period of approximately 40 years, he was a full-time judge on the Seventh Circuit Court of Appeal and a full-time law professor at the University of Chicago, and he published a book a year, along with various law review articles. And his books were on all kinds of topics. I mean, they all related to law, but all kinds of law and all kinds of approaches to law. And he was also one of, along with some people here at Berkeley, one of the people who really created the field of law and economics. An absolutely brilliant scholar and brilliant judge, a very conservative judge and scholar, which I'm not, but one nonetheless, one who I admire very much, and whose work I admire very much. I enjoy disagreeing with him. I found an article that he had written 3 years before the opinion in the Bakke case, in which he said, many people are making the argument that diversity, including racial and ethnic diversity, is a justification for affirmative action. But they're wrong. It's not, and it shouldn't be seen that way. Well, that was very interesting because before Bakke, I didn't think anyone was making that argument. And I looked for some authority. That is, I looked for his footnotes. It's the most important part of a paper. And I know people, I won't tell you their names, who when they pick up a paper, they first read the footnotes to see if they're cited, and if they're not cited, they don't bother reading the paper. In the citation, it said, this is the argument made by Harvard University in the DeFunis case. Well, the DeFunis case is a case that was dismissed as moot. And so, although it went to the Supreme Court, it then sort of disappeared from history. So I thought, well, I better look at the brief of Harvard University in the DeFunis case. So I pulled it up on Westlaw and I read it, and it didn't say anything about diversity. Okay, so I pulled up the Lexis database to see if maybe there was a second Harvard brief that Westlaw had missed. But no, they had the same one. It was from the Divinity School. It didn't say anything about diversity. So I called down to the library at the law school and I said, do we have the briefs from the DeFunis case? And they said, no, we used to collect all the briefs from all Supreme Court cases, but we've stopped doing that. You should just go look at Westlaw or Lexis. And I said, I did. I didn't find the brief I was looking for, because I think there's a Harvard brief that somehow isn't in the Westlaw or Lexis collection. And the librarian said, gee, I'm sorry. Maybe check with the Librarian of Congress. So as I'm sitting in my office, I'm trying to figure out, well, now what do I do? And the librarian calls back and says, hey, you know, I just did a search and it turns out that all of the briefs in the DeFunis case were published in a 3-volume set by the Civil Liberties Institute at the law school here. I'll send them up. This is pre-COVID. So a few minutes later, I have the 3 volumes and I look through them, and by gosh, there are 2 briefs from Harvard. And so I start reading the other Harvard brief, and it's amazing. One, it's precisely the diversity justification argument that Justice Powell is going to make 3 years later. 2, it's brilliantly written. 3, but maybe the best brief I've ever read. 3, many parts of it were clearly cut out and pasted into Justice Powell's opinion in Bakke, word for word for word. A 1,000-word segment of the brief shows up in the opinion in Bakke. And then I get to the end of the brief. And who's the author? It's the first time I realized who the author is. The author is someone named Archibald Cox. Now, how many of you recognize the name Archibald Cox? I know I've got 3 minutes left. We'll get there. Okay, Kurt and Zoe. Okay. Zoe, who is Archibald Cox?
I believe he was the prosecutor of Watergate.
He was the Watergate special prosecutor. He was a Harvard law professor. He had been the United States Solicitor General under John Kennedy. That is the person in charge of arguing cases in the Supreme Court on behalf of the United States. He was one of the great constitutional scholars of his day. He was the Watergate special prosecutor, and then he was fired by Nixon because he was asking for too much information. So he went home to Cambridge, and it was too late to start teaching because the semester had already begun. And so his friend Derek Bach, the president of Harvard, said, Archie, would you write a brief for us in the DeFunis case defending affirmative action? Which he did. That brief essentially became Justice Powell's opinion 3 years later in the Bakke case. Now, I don't have time to tell you the rest of the story. It's a great story. It's a long story, and it's getting longer because I'm still working on it. But I will tell you that when I ultimately found my way into Justice Powell's files, I found for the Bakke case a note saying to his clerk, let's use the Cox brief from DeFunis. And in the DeFunis file, him marking up that brief in a dozen places with exclamation points and saying, yes, yes, this is exactly right. So it was a wonderful thing to discover. And it's those moments that we all look forward to when we can make some amazing discovery. Not ever knowing where our scholarship is going to take us. And it takes us to some wonderful places. Now, I apologize because I had meant to leave time for questions, but I think you've got somebody else showing up in 1 minute, don't you? Yeah. So I'm happy to hear from you offline. I hope you do pursue work as scholars and as activists, and they can go together, and as teachers, and as lovers of knowledge and seekers of knowledge. And thank you.
Thank you so much, Professor. Everybody give an unmuted / camera on round of applause for Professor Oppenheimer. Thank you so much. If students have questions or are interested in your work, is there an email that we can share with them after the symposium that they can contact you at?
Sure, I'm at doppenheimer@law.berkeley.edu.
Perfect. And I will just put that in the chat for everybody. That's doppenheimer@law.berkeley.edu. Thank you so much again. That was an incredible story.
Good. I'm glad you enjoyed it. Be well. And how do I, oh, here it is.
Well, that was awesome. I hope that you all enjoyed that as much as I did. Next up, we have our first student speaker, Nolan McMahon. Nolan is a sophomore at UC Berkeley studying political science and Spanish. Nolan is extremely passionate about immigrant and refugee rights as they pertain to international affairs, and in the future, he would love to work in a field that allows him to engage with refugee law on a daily basis. Nolan's research deals with the United States treatment of refugee law and its application within certain political contexts, as well as the implications of US actions on international legal standards. Nolan, you have the floor whenever you are ready.
Can you all see this all right? Awesome. So as our wonderful host Zoe just mentioned, my name is Logan McMahon, I'm a sophomore, and today I'm going to be presenting to you all a little bit about refugee law and its implications for geopolitical jurisprudence. So just to begin, a little bit of background going over the problem of refugees on a global scale. So as of 2020, there were 26 million refugees globally, half of whom are children. And this issue presents a large challenge for states because refugee crises spanning from Myanmar to Venezuela to Syria can often occupy a lot of resources. And as a result, it can often be injurious to the functioning of states. As well, the second statistic you see on the screen here is actually the statistic that inspired most of my research. So in 2019, at the US border, 71% of asylum cases involving unaccompanied minors resulted in deportation orders. And this statistic inspired me and also my curiosity a little bit because I saw the US as a party to a slew of international agreements like the 1951 the UN Refugee Convention that seemingly affirmed refugee rights on a global scale and for refugees spanning the globe, right? But with this statistic, it was revealed to me that often the US doesn't necessarily affirm refugee rights. And so I was inspired to discover exactly when, where, and how the US diverges from or adheres to refugee law. Before I begin, a couple of useful definitions. So first and foremost, the credible fear standard. In order to be qualified as a legal refugee, individuals must express a credible or reasonable fear of returning to their home country. Essentially, what this means is that in order to qualify as a legal refugee, individuals must express to a US Customs and Border officer that they have a legitimate fear of returning to their place of persecution. In many cases, US law actually mandates that upon expression of a credible or reasonable fear, that a refugee must be sent to another officer further down the line, such that their fear can be assessed for its legitimacy. As well, the second definition on the screen, non-refoulement, pertains to stipulations established during the 1951 UN Refugee Convention, stipulating that nations, once they have accepted refugees onto their soil, they cannot relocate those refugees back to their original place of persecution. So, for example, if a Venezuelan refugee steps foot on US soil, they cannot be relocated back to Venezuela. This does, however, entail that a refugee, if they are on US soil, can be deported to a separate country that is not their original place of persecution. And so my main finding in my research is that the US maintains a policy of selective adherence to refugee law. And what this means is that the extent to which the United States adheres to or diverges from international domestic refugee law depends not on the actual qualifications of refugees for legal status, i.e. having credible fear, but instead depends on the geopolitical and domestic electoral motivations behind the acceptance of refugees. What this essentially means is that the US does not blindly or broadly apply asylum rights or refugee acceptance across the board. Instead, it looks at the political ramifications of accepting a group of refugees and then takes those into policy considerations as to whether or not they're not only going to adhere to or diverge from refugee law, but as well whether or not they're going to accept or reject a certain group of refugees. This entails that even when a group of refugees meets the threshold for legal refugeeism, they may be rejected because they don't meet certain geopolitical or domestic electoral standards. Implicit in this argument is how the US uses refugee law as a political mechanism with which to manipulate global refugee crises to their own benefit, to meet their own domestic and geopolitical objectives. All right, so why is this the case? First and foremost, with the U.S. Refugee Act of 1980, this is a case in which we see most prominently geopolitical impetus as mattering for the acceptance of and adherence to refugee law. So, as established by the RA of 1980, Congress set a refugee ceiling at 50,000 refugees to be accepted every year in the 1980s. However, the very next year, under the Reagan administration in 1981, the executive branch accepted 110,000 refugees. And this was so because the Reagan administration viewed the acceptance of refugees from Soviet Russia and Communist China as not just a valid, but rather a crucial strategy in the Cold War fight against communism. And so what becomes apparent here is how the Reagan administration went far beyond the stipulations of the Refugee Act of 1980 in order to fight global communism, and thus there was geopolitical impetus for them to defy the law and diverge from it. A second case demonstrating this is the Haitian refugee crisis in the 80s and then again in the early 90s. So in the early 80s and throughout the decade, Haitian refugees fleeing the violence of the Duvalier regime would come across the Caribbean Sea seeking refuge in the US on boats. However, many of these boats were intercepted in the middle of the Caribbean near Cuba and consequently returned to Haiti by US soldiers. And this clearly constitutes a violation of international non-refoulement law because all of these Haitian refugees were being returned to their original place of persecution. Now, why did this occur? I argue that this occurred because the US had the geopolitical impetus to support the Duvalier regime. Because of the impending threat of communist Cuba and ongoing conflicts in El Salvador, as well as Honduras, the Bush regime and the Reagan regime as well returned Haitian refugees back to Haiti as a means of supporting Duvalier as a capitalist bulwark in the middle of the Caribbean. It was seen that returning these refugees to their original place of persecution would allow the US to maintain friendly relationships with the Haitian government, such that the nation itself would remain capitalist and would not fall prey to any communist threat. However, when we see that in the early 90s, this system of breaking non-refoulement law and returning Haitian refugees to their original place of persecution continued into the early 90s under the Bush administration, what becomes apparent is how geopolitical impetus faded away, but the situation still continued because given that the Cold War was mostly over and it was seen that capitalism had won, geopolitical impetus doesn't have quite as much explanatory power. But when one considers that for Bush's re-election campaign, crucial battlegrounds like Texas and Florida, which had high levels of anti-immigrant and anti-Haitian refugee sentiment, what becomes apparent is that the Bush administration kept rejecting these Haitian refugees and diverging from refugee law in order to gain votes in crucial battlegrounds like Texas and Florida. So what we have here is in the 80s, rejection of Haitian refugees and divergence from refugee law as a means of meeting US geopolitical objectives. And then into the early 90s, the same situation occurs, but it occurs such that the Bush administration can gain votes for its re-election campaign. And then another case that demonstrates this same exact principle is the 2007 refugee crisis in Iraq Act. So in 2007, when the US had begun to extract soldiers from and recuse itself from Iraq after having deposed the Saddam Hussein regime, Congress passed a law that essentially expanded the legal definition of a refugee in order to provide legal refugeeism to a variety of Iraqi operatives who had helped us topple the regime. In effect, because these refugees had not yet faced persecution, they needed an extra law to be passed so that they could be extradited to the US, not extradited, but brought into the US and such that they could fit under the definition of legal refugeeism. And this was considered a valid strategy because and a strategy that would meet US geopolitical goals, because the US largely saw that if they could make good and follow through on their deal to these operatives to provide them with refuge in exchange for foreign policy missions and having fulfilled objectives, that they could ensure the success and security of future operations by showing other operatives in separate foreign policy contexts that the US is a nation that follows through on its promises made. And thus, in this situation, what we see is how the US had the geopolitical impetus to not only expand, but rather create an entirely new refugee law to meet their political interests. So what does this mean exactly for individual refugees? Essentially, US adjudication of legal refugee status for individual refugees depends on those same geopolitical and domestic factors. US treatment of refugees, or essentially whether or not they qualify an individual as a refugee, does not depend on their actual meeting of thresholds, i.e. meeting the credible fear standard. Instead, whether or not a refugee is accepted into the US depends principally on whether the US has the geopolitical or domestic electoral impetus to accept that refugee. And thus, instead of credible fear, I feel that a more apt standard for determining whether or not a refugee will be accepted into the US would be of geopolitical or domestic electoral impetus or significance. And to justify this, it's abundantly clear in the contrast between Central Americans in 2014 and Iraqi refugees in 2007. Central Americans in 2014, in this case, we saw a variety and thousands of Central Americans coming from the Northern Triangle countries in Central America, migrating up through Mexico and reaching the US southern border such that they could lodge asylum and refuge claims in the US. However, when many reached the border, and even upon expression of credible fear, many were not only refused to be heard, but also were rejected and sent either back into Mexico or back to their country of origin. And this, in a lot of ways, constituted a clear violation of US refugee law, because overwhelmingly 50% of Central Americans who reached the border expressed that they had a credible fear of returning home, but many fewer than even that 50% were referred to a separate customs officer to determine the legitimacy of their credible fear. And I argue that this happened for two central reasons, the first of which being that the US maintains relatively friendly relationships with the three main countries that these Central Americans were coming from, and thus there was no geopolitical impetus to accept them. And as well, areas like Texas and Arizona, where these refugees would have been relocated to, had high levels of anti-immigrant sentiment, and thus in order to maintain votes in those areas, I argue that the Obama administration rejected these refugees. And when this comes into contrast with Iraqi refugees in 2007, what becomes apparent is how the US looks primarily to the geopolitical and domestic electoral significance of refugees in order to determine whether or not they will be accepted. And this is the case because Central Americans arguably had a much better asylum case on the whole than Iraqi refugees in 2007 did, because Iraqi refugees had not yet faced persecution, whereas Central Americans were actively fleeing economic turbulence and political and gang violence in their home countries. So where exactly does this leave us? US refugee law, insofar as it manifests into policy, functions as a political mechanism. The US essentially fails to recognize humanitarian norms as set by the UN and their own domestic refugee law, and instead uses refugee law and executive policy to manipulate refugee crises around the globe to meet their own objectives. Now, why exactly does this matter? Why is it important, and what are the ramifications of the US only adhering selectively to refugee law? First, I argue that selective adherence undermines international legal structures and humanitarian norms. So the United States, as not only a party to, but a very prominent player in the international system, when they defect from or diverge or even ignore completely international refugee law, they show other nations, for instance, Russia, that the laws at hand are simply impotent or cannot be enforced, and on the whole are insignificant and don't need to be applied to any policy calculations. And as I mentioned a little bit earlier, German studies have found when dealing with Russian operatives that as a direct result of US actions, Russian foreign policy operatives are more likely to diverge from humanitarian norms as set by the UN. And this can be seen principally in the case of the treatment of recently, the treatment of Alexei Navalny. Second, selective adherence undercuts legitimacy and credibility internationally. So the US, as they continue to not only diverge from, but ignore completely uh, international domestic refugee law, they set a precedent and the image of themselves as not being credible, reliable, or predictable world actors. And this effectively makes it much more difficult for other nations to enter into agreements with them and cooperate with them because they have no idea whether or not the US is going to defect or commit themselves to actions. And continually, public opinion polls in Europe among diplomats, government officials, and the general public increasingly show that Europeans perceive the US and their own region to be two separate policy worlds that simply do not share similar visions of foreign policy. And as a result of that, it's extremely likely that in the future, the US is going to encounter a significantly larger amount of difficulty trying to broker deals on an international scale and in international forums. And lastly, selective adherence creates a moral hazard with respect to prospective refugees. So the US, as a party to all of these agreements, creates a moral hazard with their precedent of selective adherence because they actively have incentive to defect from their own agreements and refugee laws. And in this way, creates a moral hazard because a variety of refugee groups like those coming from Central America and Venezuela are continually attracted by the idea and prospect of refuge in the US and often risk their lives traveling through dangerous territory and over great distances to reach the US. However, once they arrive, they often find that the US is simply not offering the prospect of refuge, even though they had originally held it out. And thus there exists a moral hazard here in how the US is party to and holds out continually the prospect of refuge to these refugees, but then selectively retracts it and defects from their own agreements, causing large detriments to the lives of refugees who risk everything they have to find refuge in the US. And that is all I have. Thank you very much for your attention.
Thank you, Nolan, for that extremely informative speech, or talk, I guess. And just look out for his publication in our first journal publication coming up in June. And if you have any questions for Nolan, please submit them right now to Paige Barella, and she will start asking the questions for Nolan to take. So thank you so much, Nolan.
If nobody has any questions right now, that is okay. Nolan and Renee will both be staying after as well. So if you think of one and you'd like to ask it then, like, please feel free to stay after. There will be breakout rooms where Nolan and Renee will be able to answer questions. Nolan, if you don't mind, can we get a photo of you? Cool. Everybody on camera, smile. Okay, perfect. And yes, give me just 1 second. Technical difficulty.
And while Zoe is figuring out her technical difficulties, I'm going to introduce our next speaker, Renee Paulraj, who is a current sophomore at the University of Maryland, pursuing dual degrees in government and politics and information science. Currently, she is an attorney on the University of Maryland mock trial team and serves as education and outreach chair of both Girl Up and the University Student Judiciary. Renee enjoys volunteering on presidential and state legislature campaigns to empower citizens and increase voter turnout. And she hopes to volunteer with the American Civil Liberties Union and other nonprofit organizations before attending law school. So please give a warm welcome to Renee.
Okay, can everyone see this? Okay, cool. Hello, my name is Renee, and today I'm going to be talking about voter suppression, voting rights, especially as they both relate to the law. So as a quick overview, I'm first going to start out by discussing the history of federal voting rights laws, and I'm going to discuss the differences between first-generation voting barriers and second-generation voting barriers. And then I'm going to discuss two different Supreme Court cases. The first is Shelby County versus Holder, and the second, the current ongoing case called Brnovich versus the Democratic National Committee. And then finally, I'm going to wrap up with some solutions/recommendations. So to begin with the history of federal voting rights laws, the Constitution grants states with the ultimate power to regulate elections. And although some federal power over elections is granted, state legislatures have the ultimate authority to determine and execute election laws. Fortunately, what this has meant is that many states have implemented voting laws that have been discriminatory or have negatively impacted minorities. And for that reason, the federal government has intervened with a bunch of different acts in order to protect the right to vote. The first is the 15th Amendment. Now, following the ratification of the 13th Amendment and 14th, the 15th Amendment was ratified in 1870. This amendment granted African American men suffrage by stating that the rights of citizens in the United States to vote shall not be denied or abridged by the United States or by any state on account of race, color, or previous condition of servitude. However, the 15th Amendment didn't restrict states from regulating voting qualifications or minimizing their power to regulate voting rights. So despite the legal recognition of suffrage for many African American men, they continue to be disenfranchised through the use of voter suppression methods like violence, poll taxes, literacy tests, and gerrymandering. As a result, both voter registration and voter turnout dropped drastically in states. One source of voter suppression was the Ku Klux Klan, which was a white supremacist group whose members primarily targeted Black Americans through violence and intimidation. In response to the harassment of Black voters by the Ku Klux Klan, Congress passed a series of enforcement acts to fully enforce the 15th Amendment. Now, the first one was the Enforcement Act of 1870, which prohibited groups from banding together with the intention of violating any citizen's constitutional rights. In other words, it basically imposed criminal penalties on anyone who interfered with the right to vote. The first Enforcement Act did contribute to an increase of registered Black voters and candidates, but overall, it remained largely ineffective in mitigating the harassment endured by Black voters. So Congress intervened again by passing subsequent enforcement acts in 1871, which gave the federal government administrative power of national elections and empowered federal officials to supervise local polling places. Congress also passed additional voting rights related legislation and increased federal oversight through the Civil Rights Acts of 1957, 1960, and 1964. The 1957 Act created the Civil Rights Division within the DOJ, and it gave the Attorney General the authority to intervene in lawsuits seeking relief against violations of the 15th Amendment. The Civil Rights Act of 1960 established federal inspection of local voter registration polls, and it introduced penalties for anyone who attempted to obstruct someone's right to vote. The Civil Rights Act of 1964 primarily prohibited discrimination on the basis of race, color, religion, sex, or national origin. Voting rights protections ultimately culminated in the landmark Voting Rights Act of 1965. This act ensured that state and local governments don't infringe on American citizens' right to vote based on their race, color, or membership in a minority language group. This legislation prohibited voter discrimination on the basis of race, and it ultimately increased federal voter protections against first-generation election barriers like literacy tests and poll taxes. It also had a pre-clearance provision where it required jurisdictions with a history of voter suppression to obtain pre-clearance from the federal government for any changes to local voting practices or procedures. Essentially requires these jurisdictions and states to get approval from the Department of Justice for any voting changes they want to implement. And this covered around 9 states and portions of 7 other states. So in order to get that voting change approved, the covered areas needed to provide proof that the proposed voting change doesn't deny or abridge the right to vote of a minority group. And if that specific jurisdiction is unable to provide such proof, then the district court can ultimately deny the request, or the attorney general can object to the change. Since the Voting Rights Act of 1965, Congress has passed additional legislation to make the right to vote more accessible. This includes the Voting Accessibility for the Elderly and Handicapped Act, which required polling places to be physically accessible to people with disabilities. The Uninformed and Overseas Citizens Absentee Voting Act allowed overseas voters and members of the armed forces to register for and vote by mail, and the subsequent Help America Vote Act and Overseas Voting Empowerment Act ultimately expanded voting access and registration access capabilities as well. Now, most of these acts were implemented to address first-generation barriers to voting. This includes the grandfather clause many states implemented. This essentially states that those who couldn't read or those who didn't own property could vote if their fathers or grandfathers had voted before 1867. However, this law was blatantly discriminatory because practically no Black Americans could vote before 1867. So the grandfather clause really only applied to white Americans. Another source of first-generation voting barriers are Jim Crow laws. These were a series of segregation laws enacted as early as the 1890s, and they aimed to create a separate but equal status. Some of these laws were passed to make voter registration and elections more restrictive. So as a result, voter participation by Black Americans and other minority groups began to decrease. Some other methods of disenfranchisement included any combination of poll taxes, literacy tests, comprehension tests, property requirements, and in some states, Black Americans were denied the right to vote in even primary elections. Additionally, fraud and intimidation, especially by various hate groups, decreased voter turnout. Now, in contrast to these first generation voting barriers, secondary barriers are discriminatory because although minorities are allowed formal access to the political process, they're often restricted from achieving their voting strength. Several second generation barriers ultimately serve to limit the collective impact of minority voters. And these can include voter registration restrictions, voter purges, gerrymandering, and voter ID laws. Now, voter registration restrictions occur when states restrict both the terms and requirements of registration. This includes restrictions requiring documents to prove citizenship or identification, limiting the time period in which voters can register to vote, and restricting same-day voter registration results, which ultimately result in lower voter registration and lower voter turnout. Voter purges are an increasingly prevalent voter suppression tactic. They're often used by jurisdictions that were previously covered by the pre-clearance provision. And this essentially refers to the practice of removing voters from voter rolls. And it tends to be used for legitimate purposes, such as for those who have died, for those who have become imprisoned, for those who have moved to another state, or those who have become legally incompetent. However, some states have abused the practice by purging voters from rolls solely because they haven't actively voted in recent elections. Now, the right to vote is constitutionally guaranteed, and this right encompasses both the right to choose whether or not you want to vote. So by punishing eligible voters for not voting, it's essentially inherently undemocratic and unconstitutional. Furthermore, there has often been cases of inaccurate data being used for these voter purges, which has resulted in tens of thousands of eligible voters being illegally purged. So in a state with millions of registered voters, this can result in upwards of hundreds of thousands of lost eligible votes. Gerrymandering is another commonly used voter suppression tactic, often used on the basis of partisanship. Every 10 years, states use population census data to redraw district lines. And although redistricting should accurately reflect population changes and diversity, it tends to be commonly abused to alter the outcome of elections. So this is the process that is ultimately referred to as gerrymandering. And it occurs when lines are drawn to manipulate the boundaries to predetermine the outcome of elections. It primarily occurs on the basis of party identification, but it can also occur on the basis of race, which ultimately limits the voice and representation of racial minorities. Another tactic is voter ID laws. Currently, 36 states have voter identification requirements at polling places. 7 states have strict voter ID laws under which voters must present one of a limited set of forms of government-issued ID in order to cast a ballot. The United States Government Accountability Office estimates that voter ID laws tend to reduce voter turnout by 2 to 3%. So once again, in a state with millions of eligible and registered voters, this can result in a lot of votes being lost. Now, proponents of voter ID law stress the importance of verifying a voter's identity before allowing them to cast their vote. They cite cases of registered voters voting in multiple states, non-citizens voting, and people fraudulently voting by claiming a deceased voter's identity. Meanwhile, opponents to voter ID laws cite their disproportionate impact and burden on minorities. Currently, 11% of US citizens lack government-issued voter identification. And of these, minority voters disproportionately lack such government-issued photo ID. Nationally, around 25% of African-American citizens lack ID compared to 8% of white citizens. And additionally, obtaining that government-issued photo ID can be costly or burdensome, especially on low-income individuals. The travel required to get an ID is often an obstacle for people with disabilities, the elderly, and people living in rural areas. And it can pose a financial burden because many voters would have to incur costs such as paying for birth certificates and other document fees in order to even apply for the government-issued ID. So this is the first Supreme Court case I'm going to discuss. And basically in April 2010, Shelby County, Alabama filed a lawsuit asking for a federal court in Washington, D.C. to declare Section 5 of the Voting Rights Act as unconstitutional. Section 5 requires certain jurisdictions with a history of discrimination to submit any proposed changes in procedures to the U.S. Department of Justice or a federal district court in D.C. This essentially is what the pre-clearance process is about. Both the District Court and Court of Appeals upheld the constitutionality of Section 5, but Shelby County appealed the ruling to the Supreme Court. And in 2013, the Supreme Court ruled that the coverage formula in Section 4B of the Voting Rights Act, which determines which jurisdictions are covered by Section 5, is unconstitutional because it's based on an old and outdated formula. As a practical matter, this meant that Section 5 remained inoperable until Congress enacted a new updated coverage formula. And Section 5 required certain jurisdictions to receive that pre-clearance. So since that ruling, voter suppression has become increasingly prevalent because that pre-clearance provision no longer applies. In 2013 and 2014, at least 10 of the 15 states that had been covered in whole or in part by Section 5 introduced newly restrictive voter legislation that would make it harder for minority voters to cast a ballot. The use of these voter suppression methods, including voter ID laws, considerably increased following the Supreme Court's ruling in Shelby County versus Holder. The effects have mainly been felt at the local level, as the majority of voting law changes that were restricted as discriminatory were local counties, towns, and other places that operate below the state level. One example is Galveston County, Texas. Recently, following the ruling in 2013, Galveston County revived a redistricting plan for electing justices that was previously blocked by the DOJ because it discriminated against minority voters. Similarly, another example is Georgia, where officials changed the dates of 2 elections. And citing Section 5, the DOJ blocked a similar proposal in 2012 because it disproportionately reduced Black American voter turnout and participation. Other states have also introduced restrictive legislation that makes it more difficult for minorities to cast a vote. Virginia passed a strict voter ID requirement and increased restrictions on third-party voter registration. North Carolina also passed ID requirements, early voting cutbacks, and eliminated same-day voting registration. Since the Shelby County decision, plaintiffs have generally challenged these strict voter ID laws through Section 2 of the Voting Rights Act. Through such a claim, plaintiffs can challenge the laws by demonstrating that they disproportionately affect minority voters to the extent of diluting the vote of that minority group as a whole, resulting in an abridgment on the right to vote based on race or color. Now, one example is in 2011, Texas passed Senate Bill 14. This was a voter ID law that required voters to present photo identification in order to vote in person. Specifically, this bill required voters to present a state-issued voter ID card or a photo ID from a limited list of acceptable IDs prior to voting. Now, prior to the Shelby County decision, the DOJ claimed that this law placed an undue burden on minority voters and rejected it pursuant to Section 5. But since the Shelby County decision, this bill was ultimately implemented, so its legality was challenged through Section 2. And the court case was actually called BC versus Abbott, where the Fifth Circuit Court of Appeals found that Texas Senate Bill 14 also violated Section 2 of the Voting Rights Act. Following its implementation in 2013, the Fifth Circuit ultimately affirmed that Senate Bill 14 had an unlawful disparate impact on African American and Hispanic voters and thus violated Section 2. A similar case happened with North Carolina with their House Bill 589, which created additional voting requirements, including strict photo ID changes. In July 2016, the Fourth Circuit Court of Appeals struck down this bill in its entirety because it violated Section 2 of the Voting Rights Act by targeting racial minorities. And this is the second Supreme Court case that's currently ongoing that I'm going to discuss. This is a case involving two electoral policies in Arizona. The first is a ban on third-party ballot collection, which is referred to as ballot harvesting. This effectively prohibits third-party collection and delivery of voters' absentee ballots with limited exceptions. Opponents of this law point to its especially detrimental effect on Native American voters because many Native American voters live in rural areas and don't really have access to reliable mail services. So they really rely on the ballot collection. Now, the second policy at issue invalidates ballots cast in the wrong precinct, even if those ballots include votes for statewide races where all Arizona citizens choose among the same candidates regardless of the precinct location. Challengers of this policy contend that combined with Arizona's tendency to frequently change precinct locations, it disproportionately impacts Latino and other minority voters in Arizona. In 2016, the Democratic National Committee and the Arizona Democratic Party challenged these two policies under Section 2 of the Voting Rights Act. And this is a claim which prohibits any standard, practice, or procedure that results in a denial or abridgment on the right to vote of any citizen in the United States on account of race or color. This case is ultimately important because both sides propose their own version of the vote denial test, which is a standard that's used to assess whether an election policy denies the right to vote on the basis of Section 2. And since Section 5 was struck down in Shelby County, Section 2 really remains as a lifeline for all of these cases. So to combat such voter suppression and restrictive legislation being implemented by states, several policy solutions need to be implemented at the federal level. And this includes more comprehensive voting rights legislation. One potential solution is for Congress to devise a new updated coverage formula for pre-clearance. With the Shelby County ruling, since that pre-clearance formula was struck down because it was too broad and outdated, the court did invite Congress to create a new updated coverage formula that would be considered constitutional. Additionally, with this pre-clearance provision would fall under the John Lewis Voting Rights Advancement Act, which does establish this new coverage formula, and it also takes into account more modern issues of voter discrimination. One of the Act's provisions specifically analyzes the practices that have been problematic in the past and sets forth criteria for which those practices can be subject to pre-clearance. A second option is the For the People Act, which ultimately modernizes voter registration and takes other steps to improve voting access in federal elections. It expands access to registration by providing online voter registration methods for federal elections, and it would require states to use automatic voter registration methods for these federal elections. This act is estimated to register up to 50 million new eligible voters while increasing the accuracy of voter registration rolls. Both of these solutions should be implemented at the federal level, ultimately to protect the right to vote and expand access to the ballot. And these are our list of references. And if anyone has any questions, I can take them now or in the breakout room.
Awesome. If anybody has any questions, first, everybody give a round of applause to Renee. Thank you so much for speaking, Renee. What an amazing talk, and what inspiring inspiring bills that are in the Senate or could possibly be in the Senate in the future. If anybody has any questions for Renee right now, please direct them and message them to Paige Barella, and Paige will let us know if there are any questions. While that's happening, Renee, do you mind if we get a photo with you?
Oh, yes, definitely.
Perfect. Cool. Everybody say legal scholarship at the undergraduate level is great. Yay. Okay, thank you so much. Paige, are there any questions coming in through the chat.
No, there are not, but thank you to our speakers today. You guys were all wonderful.
Okay. Well, we can go ahead and then I'll open up the breakout rooms in just a little bit. I want to thank all of you so much for coming and staying through until the end. We are so grateful to have all of your support and all of your attendance here today. We hope that you enjoyed it and are left energized and inspired with all of the amazing legal scholarship that's coming from our student writers. Just a couple of announcements. We are opening up our writer application for our fall 2021 journal tonight, and we'll have more information on that for you later. So if you are interested in writing for the pre-law review at Berkeley, especially now after hearing all of the cool things that our current writers are researching and writing about, then please stay up to date on our socials. You can just look up Pre-Law Review at Berkeley. We're on all of the social medias as well as CalLink, or you can email us at calprelawreview@gmail.com to stay up to date on our recruitment timelines, as well as when we get our website up and running and publish our journal. Other than that, it was truly an honor hosting this and getting to see all of your wonderful faces and hear from our amazing speakers.